He was 17 years old when he called 911 and told the dispatcher his parents had been attacked in their own home. Within 12 hours, the police in Suffolk County, New York, believed he had done it himself. Within 2 years, a jury agreed. It would take 17 years, one lie told by a detective to a dying man's son, and the disappearance of a business partner 3,000 miles away before the truth caught up with the case. On the morning of September 7, 1988, in the quiet gated village of Belle Terre, on the north shore of Long Island, a teenager walked down a hallway in his family's house on Seaside Drive and found his mother dead on the floor of her bedroom. His father was a few feet away, alive, barely, his skull fractured, his throat cut. The boy's name was Marty Tankleff. Everyone who knew him called him Marty. He would spend the next 17 years of his life inside a New York State prison for a crime the evidence never actually proved he committed. This is the story of a false confession that was never signed, a lie told by a police detective that should have ended a career instead of a childhood, and a murder that, decades later, still does not have a single person convicted of committing it. There is a single detail at the center of this case, and it is worth holding on to from the very beginning, because everything else, the trial, the 17 years, the eventual reversal, turns on it. Seymour Tankleff never regained consciousness after the attack. He never spoke again before he died. And yet, within hours of the murder, a detective told his 17-year-old son that he had. Seymour Tankleff was 62 years old in the fall of 1988, and by the standards of Belle Terre, he had done well for himself. He owned a chain of bagel stores across Long Island, held interests in real estate, and belonged to a local country club where he played cards most weeks with the same rotating group of men. He lived with his wife, Arlene, in a large house behind the gates of one of the wealthier villages on the North Shore, the kind of place where the local police department knew most residents by name, and where the department's typical caseload ran to stolen bicycles and fender benders at the village gate, not homicide. Arlene was 55. Neighbors and friends would later describe her consistently and without contradiction as warm, private, and devoted almost entirely to her son and her home. She was, by most accounts, the emotional center of the household, the parent Marty was closest to, the one whose bedroom he would eventually find first that morning. She was known in the neighborhood for small, specific kindnesses, driving carpool for other families' children, keeping a spare key for an elderly neighbor down the block, the kind of quiet, repeated generosity that rarely makes it into a police report, but that shapes, more than almost anything else, how a community remembers a victim once the case has faded from the headlines. That is worth naming plainly, because so much of what followed in this case became a story about the accused. Arlene Tankleff deserves to be remembered first as more than a crime scene. Marty was their only child still living at home. An older half-sister, Sherry, from Arlene's previous marriage, had already moved out and started her own life by 1988. Marty was a senior at Bellport High School that fall, 17 years old, a competitive tennis player who practiced most afternoons on the courts near his house, a kid without a juvenile record, without any documented history of conflict with either parent serious enough to have drawn attention from teachers, coaches, or extended family. Teachers and classmates interviewed in the years that followed described him in almost uniformly unremarkable terms. A decent student who was not exceptional, but not struggling either, well-liked by his peers, close to his mother in a way some of his friends noticed and mentioned specifically, and someone who worked part-time in one of his father's businesses on weekends, learning the family trade the way many kids of small business owners on Long Island did. None of that would matter in the end, nearly as much as what one detective decided about him in the first 6 hours after the murder. The tennis mattered more than it might seem in hindsight. Marty had spent that particular summer, the summer of 1988, largely on the court, working toward a competitive ranking within his age group on Long Island, a pursuit that required discipline, early mornings, and a level of physical conditioning inconsistent with the picture prosecutors would later try to paint of a resentful, checked-out teenager simmering with hidden rage toward his parents. Coaches who worked with him described a kid who showed up on time, who took correction well, who did not, in any documented instance, display the kind of volatility that true crime narratives so often retroactively assign to defendants once a conviction is already secured. That absence of a documented history is itself a kind of evidence, not proof of innocence, but the absence of the pattern investigators typically look for and typically find when a teenager actually does turn violent against a parent. By most accounts, the Tankleff household was not a house divided against itself. There was money, there was the appearance of stability, and there was, at least on the surface, a functioning family with the ordinary rhythms of suburban affluence: tennis lessons, a country club membership, a comfortable house, family dinners. But underneath that surface sat something else, a business partnership that had gone sour, involving a man named Jerry Steuerman. Steuerman co-owned the bagel stores with Seymour Tankleff, and the two men had been partners for years, building the chain up from a smaller operation into a genuinely profitable local business. By 1988, according to court testimony and later investigative reporting, the relationship had curdled into something closer to a grudge than a partnership. Steuerman reportedly owed Seymour a substantial sum of money, reporting at the time and in the years since put the figure in the hundreds of thousands of dollars, tied to a buyout agreement the two men had negotiated, but never fully settled to Seymour's satisfaction. Associates of both men later testified, or told investigators working the case in subsequent years, that the disagreement had grown tense enough that Seymour had confided his frustration with Steuerman to friends in the weeks before the murder, describing a partner he no longer fully trusted with money. On the night of September 6, 1988, Steuerman was one of several guests at the Tankleff house for a poker game that ran late into the evening, a regular fixture among this particular circle of Belterre men. By his own account, and by the accounts of the other players who were later interviewed, Steuerman was one of the last people to leave, sometime around midnight or shortly after. The other men at that poker table, interviewed separately by police in the days after the murders, gave largely consistent accounts of an unremarkable evening. Cards, conversation, the usual rotation of small talk among men who had known each other for years through business in the country club. None of them reported any visible argument between Seymour and Steuerman that particular night, though several later told reporters that the tension between the two men had become something of an open secret among their circle, the kind of thing everyone quietly understood but no one discussed directly at a card table. That gap between what people privately understood about the Tankleff-Steuerman relationship and what actually made it into a police report in September of 1988 is itself part of the story, a reminder that investigations are only as good as investigators' willingness to keep pulling on threads that don't point toward the suspect already in the room. Marty was not at the poker game. He had spent the evening with friends, come home sometime before midnight, and gone to bed in his room down the hall from his parents' bedroom, in a house that had, by every account given afterward, been entirely ordinary and entirely quiet when he fell asleep. Sometime in the hours that followed, the exact window remains, to this day, a matter of forensic dispute, complicated by the medical examiner's estimates of time of death and conflicting accounts of exactly when the last poker guest actually left the property. Someone entered the master bedroom of the Tankleff house and attacked both Seymour and Arlene with, investigators believed, more than one weapon: a blunt object, possibly a dumbbell taken from a nearby exercise area of the house, and a bladed weapon used against both victims' throats. Neither weapon was ever recovered, despite an extensive search of the property and surrounding grounds, including the wooded areas bordering the back of the house and a nearby stretch of Long Island Sound shoreline within walking distance. No fingerprints belonging to an outside party were ever definitively matched at the scene, a fact the prosecution would use to argue there had been no intruder, and the defense would use to argue the scene had simply never been processed with the rigor a double homicide of this kind demanded, pointing out that fingerprint recovery from cloth, from carpeting, and from many household surfaces was, by forensic standards even in 1988, notoriously unreliable, and that an absence of prints proves considerably less than prosecutors suggested it did in front of a jury unfamiliar with those limitations. At approximately 6:10 in the morning, Marty Tankleff called 911. His voice on that call, preserved in the emergency dispatch recording and later played and replayed in court and in the press for decades afterward, is the voice of someone who has just found his mother's body and his father barely alive beside her. He told the dispatcher there had been an attack. He said he didn't know who did it. He asked more than once for help to hurry, his voice cracking audibly on the recording. Police arrived within minutes. The first officers on scene found the house largely as Marty had described it. Doors locked, no shattered windows, no obvious point of forced entry anywhere along the perimeter of a house that, like most homes in Belle Terre, had a security gate at the edge of the property, but no individual home alarm system active that night. A sliding door off the back of the house was later found unlocked, a detail both sides would spend years arguing over, the prosecution treating it as unremarkable, the family's normal habit, the defense treating it as the entry point an intruder familiar with the house's layout would have known to use. Investigators noted the time on a kitchen clock, the position of playing cards left from the previous night's poker game, the untouched state of a jar of cash Seymour reportedly kept in a downstairs drawer, small, ordinary domestic details that would later be picked apart, sentence by sentence, in a courtroom by lawyers trying to reconstruct a sequence of events from the physical residue of an otherwise unremarkable Tuesday night. Arlene Tankleff was dead at the scene, killed by a combination of blunt force trauma and a slashed throat. Seymour was alive but critically injured with similar wounds and was rushed by ambulance to Long Island Jewish Medical Center, where he was placed in intensive care and within hours fell into a coma. He never regained consciousness. He died 3 weeks later, on September 29, 1988, without ever speaking another word to anyone, not to a doctor, not to a nurse, not to a detective, and not to his son. That fact will matter more than almost any other fact in this story. Because within hours of the murder, before Seymour Tankleff had even been declared medically stable, a police detective would tell Marty that his father had spoken and named him. Detective James McCready of the Suffolk County Police Department was among the first investigators to arrive at the scene that morning, and within a matter of hours, well before any forensic analysis had been completed, he had already settled on a theory that Marty Tankleff had killed his parents. There was no physical evidence connecting Marty to the crime beyond what would be expected of a teenager who had just discovered and touched his badly injured father and his dead mother. Some blood transfer on his hands and clothing, consistent with contact and attempts to check for signs of life, not consistent with the kind of blood spatter pattern an assailant delivering the wounds themselves would carry. No weapon was found in his possession or anywhere connected to him. No witness placed him doing anything other than what he told police he had done, waking up, going downstairs, and finding the scene. What McCready had, instead of evidence, was a set of impressions, formed quickly and held on to stubbornly for the rest of his career. He would later testify and tell reporters over the years that the crime scene looked too controlled for a break-in. No obvious signs of forced entry, no ransacking consistent with a burglary gone wrong, drawers and cabinets left largely undisturbed. He noted that Marty, in his estimation, did not appear sufficiently distraught in the minutes after police arrived, an assessment that decades of subsequent research into acute trauma response would characterize as deeply unreliable as an investigative tool, since shock manifests in wildly different ways from person to person, and a flat or numb affect in the immediate aftermath of extreme violence is not in itself evidence of guilt. And he noted that Marty, as an only child still living at home, stood to inherit from his parents' estate, a motive theory that ignored the far more concrete, far better documented financial motive sitting one poker table away from the crime scene the night before, in the person of a business partner who owed a six-figure debt to the man now dying in a hospital bed. Marty was brought to Suffolk County Police Headquarters that same morning while his father was still in surgery. He was not placed under formal arrest at the outset. He was not read his full rights before questioning began. No parent was present, since his only surviving parent was unconscious and his half-sister lived out of state. No attorney was present. Under New York law at the time, 17-year-olds were treated as adults within the criminal justice system for serious offenses. A legal quirk that meant a boy who could not legally buy a lottery ticket or vote could nonetheless be interrogated alone for hours in a double homicide investigation without any of the additional procedural protections typically extended to juveniles in other contexts. That interrogation stretched on through the morning and into the afternoon, hour after hour, in a small room at Suffolk County Police Headquarters. At some point during those hours, McCready told Marty something that was not true. He told him that his father had woken up from the coma. He told him that Seymour Tankleff, lying in a hospital bed 20 miles away, had regained consciousness, spoken, and named his own son as the person who attacked him. This was entirely and demonstrably false. Seymour Tankleff was, at that exact moment, unconscious in an intensive care unit, and he would remain unconscious for the 3 weeks of life left to him. He never regained consciousness. He never spoke. He never named anyone, to anyone, at any point after the attack. But the lie worked precisely the way an interrogation tactic like this is designed to work on a person with no experience navigating a police investigation. Confronted with the claim that his own father, a man he had just found bleeding on the bedroom floor hours earlier, a man he loved, a man whose word he had no reason to doubt, had accused him by name, a 17-year-old alone, exhausted, and without counsel, began to doubt the reliability of his own memory of the previous night. According to the interrogation record, McCready's handwritten notes, since no tape or video of the exchange exists, a fact the defense would highlight for the next 17 years, Marty began to speculate out loud about whether it was possible he had blacked out, whether he might have done something violent without any memory of it. He floated the idea as a hypothesis in the confused, self-doubting language of someone being told an impossible thing by an authority figure he had, up to that point, no reason to distrust. That hypothetical, halting, self-doubting statement, never reduced to a signed confession, never captured on tape, existing only in one detective's handwritten account of what Marty allegedly said in a room with no independent witness present to verify it, became the central piece of evidence in the case that would put him in prison for 17 years. Marty recanted within hours before the day was even over. By the time he was formally charged, he was telling anyone who would listen, his attorney, reporters, his extended family, that he had not killed his parents, that the statement attributed to him had been the product of confusion and fear under sustained psychological pressure, and that he had never confessed to anything in the ordinary sense of the word. He had wondered aloud, under duress, whether an impossible thing his interrogator told him was true might somehow be true. It did not matter. He was charged with the murder of his mother, and later, after his father's death 3 weeks on, with the murder of his father as well. The trial took place in the spring and summer of 1990, nearly 2 years after the murders, delayed by pre-trial motions and appeals over the admissibility of the interrogation statement itself. The defense argued forcefully that the statement should never reach a jury at all, that it had been obtained through a deliberate, documented falsehood told to a minor in an unrecorded custodial interrogation, and that its unreliability as evidence should have disqualified it outright under the standards courts use to evaluate the voluntariness of a confession. The trial court disagreed, ruling that the statement, while obtained through deception, did not rise to the level of coercion required to exclude it, and the statement went to the jury. The prosecution's case rested heavily on that statement, supplemented by circumstantial arguments about the crime scene. The absence of obvious forced entry, minor inconsistencies in the timeline Marty gave police across multiple retellings, and testimony characterizing the family's finances and inheritance structure in a way meant to suggest motive. The defense countered with what would become, over the following 17 years, the foundation of the case for Marty's innocence, that no physical evidence tied him to the murders, that the timeline made it implausible for him to have committed a two-victim, two-weapon assault, cleaned himself up thoroughly enough to leave no incriminating spatter, disposed of both weapons without a trace anywhere on or near the property, and then called 911 within the window available, all without waking a single neighbor in a quiet, gated community. The defense also argued that an entirely separate, better-documented motive existed just down the hall from where the poker game had broken up hours before the murders. The jury did not hear extensive testimony about that alternate theory, the one involving Jerry Steuerman, the business partner with the six-figure debt. Because by the time of trial, that theory had already been complicated by something Steuerman himself had done in the days after the murders, something that a man with nothing to hide does not typically do. He disappeared. Roughly a week and a half after the murders, Jerry Steuerman left New York for California. He shaved his beard and, according to later reporting, took deliberate steps to alter his appearance and adopt a different identity while he was there, checking into hotels under names that were not his own. A short time later, word began to circulate, through channels that were never fully traced back to their origin, that Steuerman had died. He had not. Investigators and reporters eventually located him alive in California and brought him back to New York to answer questions about his whereabouts and his financial relationship with Seymour Tankleff. He was interviewed extensively by Suffolk County detectives. He was never charged with any crime connected to the murders. He maintained then and later that he had left New York because he genuinely feared for his own safety in the aftermath of his business partner's death, not because he had anything to do with causing it. Whether that fear was genuine, or whether it was the fear of a man who knew exactly what had happened and exactly who might come looking for him next, is a question the criminal justice system never formally resolved. The jury deliberated for 8 days following a trial that had stretched across 13 weeks, a length of time on both counts that defense attorneys would later point to as evidence the case was genuinely close on the merits, not the kind of overwhelming, open and shut prosecution the sentence that followed might suggest. When the verdict came back guilty on both counts of second-degree murder on June 28, 1990, Marty, according to courtroom reporters present that day, showed almost no visible reaction, the same flat affect that had first drawn Detective McCready's suspicion in the hours after the murders, now on display again, in front of the same skepticism, in front of a room instead of a single detective. On October 23, 1990, Marty Tankleff was sentenced to 50 years to life in a New York State prison, 2 consecutive terms of 25 years to life for the murders of his mother and his father. He was 19 years old when he began serving that sentence, transferred from the county jail where he had awaited trial to a maximum security facility built for men who, in most cases, were decades older than he was. To understand how a case this thin produced a conviction this severe, it helps to understand what was and was not standard practice in police interrogations in 1988. The Reed technique, the dominant interrogation methodology taught to American police departments for much of the 20th century, explicitly permits investigators to lie to suspects about the existence of evidence, about what witnesses have said, and about what co-defendants have supposedly admitted. Decades of subsequent research by psychologists studying false confessions has demonstrated repeatedly that this kind of deception is disproportionately effective on juveniles, on people with no prior experience of the justice system, and on people in acute grief or shock. A description that, in September of 1988, fit Marty Tankleff more precisely than it fit almost anyone the interrogation manuals had in mind when the technique was written. McCready was not operating outside the accepted norms of American policing at the time. He was operating, more or less, exactly within them, which is, in its own way, the more disturbing fact underneath this specific story. National data compiled by organizations that track wrongful convictions has, in the decades since, put a number on how often this exact dynamic repeats itself. Among cases overturned by DNA evidence in the United States, roughly a quarter have involved a false confession or a false admission of guilt as part of the original prosecution's case. A statistic that includes a disproportionate number of juveniles, people with intellectual disabilities, and people like Marty, questioned for extended periods without a parent, guardian, or attorney present. Marty Tankleff's case did not involve DNA evidence either convicting or clearing him, which is part of why it took an appellate court rather than a laboratory to undo the conviction. But it fits the same underlying pattern researchers have identified again and again: a long interrogation, a young and inexperienced suspect, an authority figure willing to deceive, and a resulting statement treated by a jury as though it carried the same weight as a signed, voluntary, recorded confession, when it was none of those three things. What happened over the next 17 years is, in its own way, as much a story about persistence as the crime itself was a story about a broken system. Marty's conviction was appealed almost immediately, and in December of 1993, the Appellate Division of the New York Supreme Court affirmed it, but only barely, by a divided vote of 3-2, with the two dissenting judges writing that the evidence presented at trial had been insufficient to support a conviction at all. A federal habeas corpus petition followed and was denied in January of 1997 by U.S. District Judge Thomas Platt. That denial was upheld a year later by a unanimous panel of the Second Circuit Court of Appeals. By the late 1990s, on paper, Marty Tankleff had exhausted almost every conventional legal avenue available to him and had lost every single one. What kept the case alive after that was not another appeal. It was a retired NYPD homicide detective and hostage negotiator named J. Salpeter, who took up the investigation largely on his own time and, by most accounts, largely without pay, driven, he later said, by his own professional instinct that the original case had never actually been solved. Attorney Bruce Barkett joined the legal effort to reopen the case, filing motion after motion through a court system that had, by then, already rejected the defense's arguments twice. What Salpeter found was not a single smoking gun piece of forensic evidence sitting untouched in an evidence locker somewhere, waiting to be tested. What he found, built up patiently over years of unpaid investigative work, door-knocking and re-interviewing witnesses who had never been fully questioned the first time around, was a pattern. He identified men connected to Jerry Steuerman's circle, Joseph Creedon, known to associates by the nickname Guns, and Peter Kent, who had reputations developed through multiple independent sources over years of digging, for exactly the kind of work a man facing an unpayable six-figure debt and a soured, hostile business partnership might be desperate enough to arrange. In 2003, Salpeter tracked down and located a man named Glenn Harris, who gave investigators a sworn statement that he had personally driven Creedon and Kent to the Tankleff house on the night of the murders and driven them away again afterward. That was not the only new piece of evidence Salpeter and Barkett's team surfaced. A bloody imprint on a bedsheet in Arlene Tankleff's room, one that appeared on closer forensic review years later to be consistent with the shape of a knife, had never been meaningfully investigated at the time of the original crime scene work. And separately, evidence emerged that Detective James McCready, the same detective who had told a 17-year-old that his comatose father had named him, had himself come under a department investigation for perjury unrelated to this case, that he had violated police department rules by showing crime scene photographs from the Tankleff murders to unauthorized people outside the investigation, and that at least 2 witnesses independently told investigators they had seen McCready together with Jerry Stuerman before the murders ever took place. Sit with that for a moment. The detective who decided within hours and without evidence that a grieving teenager was guilty, the same detective who fabricated a claim about a dying man's words to extract a statement, had, according to multiple independent witnesses, a prior relationship with the very business partner whose motive the investigation never seriously pursued. That fact does not, on its own, prove that McCready acted with anything beyond bad judgment and professional overreach, but it recontextualizes every decision he made in the first 24 hours of this case. Decisions that, until this evidence surfaced, had simply been chalked up to an inexperienced department jumping to the easiest conclusion in the room. And in the years that followed, Glenn Harris's sworn account, placing Creedon and Kent at the scene and himself behind the wheel, became the centerpiece of a formal effort to reopen the case. What Harris ultimately described was not an elaborate conspiracy, but something closer to a favor gone catastrophically far. A late-night drive at Creedon's request, dropping him near the Tankleff property, and picking him up again a short time later, without, Harris maintained, fully understanding in advance what Creedon intended to do once he was out of the car. Whether that account is complete or whether it minimizes Harris's own knowledge and involvement is a question that was never fully tested under cross-examination in open court, because Harris himself never took the witness stand. At a hearing in July of 2004, Suffolk County Judge Stephen Braslow declined to grant Harris immunity from prosecution, and Harris, facing that risk, invoked his Fifth Amendment right against self-incrimination and refused to testify. Instead, with Harris's permission, a Catholic prison chaplain, to whom Harris had confided the same account, testified in his place about what Harris had told him, second-hand testimony about a first-hand account, exactly the kind of evidentiary compromise that defines so much of this case's afterlife. It exists, as a result, in sworn statements, in a chaplain's testimony, and in the appellate record. Evidence a higher court eventually found credible enough to help unravel one conviction, but never developed, under oath and cross-examination, into the foundation of another. The legal path from that accumulated evidence to an actual overturned conviction was neither quick nor guaranteed. Braslow, at the trial level, ultimately declined to grant Marty a new trial based on the 2004 hearing, forcing Barkett and Marty's legal team to appeal that decision as well, up through the New York court system, one more rejection in a string that stretched back to 1993. The appellate division finally took up the case directly, reviewing the full record, Harris's statement, the chaplain's testimony, the bloodied sheet, and the questions surrounding McCready himself. And in December of 2007, unanimously vacated Marty Tankleff's conviction and sentence outright. 17 years of a person's life, in other words, were not undone in a single dramatic courtroom moment. They were undone across nearly 2 decades of incremental legal grinding, one denied motion and one newly surfaced piece of evidence at a time. None of this proves with the certainty of a criminal conviction exactly who killed Seymour and Arlene Tankleff. No one has ever been convicted of their murders. Not Creedon, not Harris, not Stuerman, not anyone else. What the accumulated evidence did prove, to the satisfaction of a New York appellate court, was that the conviction of Martin Tankleff, could not stand on the record that produced it. In December of 2007, the Appellate Division of the New York Supreme Court overturned Marty Tankleff's conviction, citing the weight of the newly developed evidence pointing toward alternate suspects and the fundamental unreliability of a statement extracted through a fabricated claim that a comatose, dying man had spoken and named his own son. Marty was released on bail shortly afterward, after having spent nearly 17 years incarcerated, walking out of a courthouse into a wall of television cameras that had not existed in anything like their modern form when he went in. The case did not simply end there. Because the underlying homicide remained legally unsolved, New York Governor Eliot Spitzer appointed Attorney General Andrew Cuomo as a special prosecutor in January of 2008, tasking his office with reinvestigating the murders from the ground up, independent of the Suffolk County District Attorney's Office that had prosecuted Marty in the first place. Cuomo's team spent months re-examining the entire case file, including the new evidence involving Creedon, Kent, and Harris. On June 16, 2008, Cuomo's chief trial counsel told the court plainly that the question was not whether there was some evidence, but whether there was sufficient evidence, and moved to dismiss the indictment against Marty outright. In that same motion, prosecutors announced something that complicates any tidy version of this story. They said they would not proceed against Creedon, Kent, or anyone else identified by Tankleff's own defense team, stating that, on balance, the defense's theory of who actually committed the murders did not appear to be supported by clear evidence either. On July 22, 2008, a judge formally dismissed all charges against Marty Tankleff. He would never face retrial. He was 36 years old when the last charge was formally dropped. He had entered prison as a teenager who had just watched his mother's body carried out of the house he grew up in. He walked out as a man who had spent his entire 20s and the early years of his 30s behind bars for a crime the same legal system that convicted him could no longer credibly claim he had committed. The human cost of those 17 years is not abstract, and it did not end the moment the prison doors opened. Marty Tankleff lost both of his parents in a single night in September of 1988, and then lost his own adolescence, his 20s, and the better part of his 30s to a sentence built substantially on a lie told by the very detective investigating their deaths. He has spoken in interviews and public appearances in the years since his release about the specific singular cruelty of being told at 17 years old, hours after finding his parents attacked, that the father he had just tried to save had accused him. A claim that was not simply wrong but categorically impossible, and one the detective delivering it either knew, or had every reason to know, was impossible at the moment he said it. He has also described in less detail, but no less pointedly, the ordinary losses that don't make it into court records. Missing his sister's milestones, missing every family holiday for 17 years, aging inside a maximum security facility surrounded by men convicted in many cases of crimes he himself had never committed. He has said he taught himself law in the prison library, largely because no one else was going to do it for him, spending years learning the very system that had failed him from the inside of one of its buildings. He was moved between multiple New York State correctional facilities over the course of his sentence, each transfer requiring him to rebuild whatever fragile stability he had managed to establish: a job assignment, a study routine, relationships with a small number of people inside who believed his account of events. Fellow inmates who spent time alongside him in later years described someone who did not fit the profile of the facility's general population in an obvious way. A man in his 20s and 30s who spent his free hours reading case law and appellate procedure instead of the alternatives available to him, treating his own legal file the way a paralegal might treat a client's. Because in the most literal sense, for years, he was both. The extended Tankleff and Sturman families and the wider Belterre community absorbed a version of this trauma as well. Friends of Arlene's were, according to contemporaneous reporting, deeply divided over the years, some certain of Marty's guilt because the courts had said so, others convinced from the very beginning that a grieving teenager had been failed twice, once by whoever attacked his parents and once by the system that was supposed to find out who. Reunions, funerals, and even routine community gatherings in Belle Terre reportedly carried an undercurrent of this division for years, a small, wealthy village permanently marked by an unsolved double homicide that had, on paper, been solved. Media coverage of the case shifted dramatically across those 17 years, in a way that tracks a broader shift in how the American press has come to cover the criminal justice system generally. In 1988 and through the 1990 trial, most coverage treated the prosecution's version of events as the presumptively correct one, describing Marty in early reporting with language that leaned on the same assumptions McCready had made in the interrogation room. A teenager who didn't act the way a grieving son was supposed to act, therefore a teenager worth suspecting. By the mid-2000s, as Salpeter's investigation and the 2004 evidentiary hearing reached wider audiences through sustained New York Times and Newsday coverage, the framing began to change, with some of the same outlets that had once treated the conviction as settled fact now revisiting it with open skepticism. That shift did not happen because new physical evidence appeared out of nowhere. It happened because a retired detective and a small legal team did the slow, unglamorous work of re-examining assumptions that had gone unchallenged for over a decade. The same kind of work this channel tries, in its own way, to continue. James McCready never faced criminal charges, professional discipline, or any formal sanction for the fabricated claim about Seymour Tankleff's condition. Interrogation tactics involving false statements about evidence or about what a co-defendant or witness has supposedly said are, under long-standing case law in the United States, generally permitted, so long as they don't cross into what courts define as coercion severe enough to render a resulting statement involuntary. Whether telling a 17-year-old boy that his dying, comatose father had accused him of murder crosses that line is a question the courts ultimately answered. 17 years too late for Marty Tankleff to get those years back. The original investigation carried other, quieter failures beyond the interrogation itself, the kind that rarely make headlines but accumulate into the same result. Crime scene photographs taken in the hours after the murders were later criticized by defense forensic experts for gaps in coverage, angles not photographed, areas of the bedroom not swabbed for evidence that later testing methods might have been able to use. Suffolk County's Homicide Squad in 1988 was, according to reporting from the period, a department more accustomed to the occasional gang-related or domestic homicide than to a case with this much money, this much possible motive, and this many people who had been in the house hours before the murders. Investigators reportedly spent limited time on a full forensic accounting of Steuermann's financial records in the immediate aftermath, at precisely the moment when that paper trail would have been freshest and hardest to alter. Bank records, partnership agreements, and correspondence between Seymour and Steuermann over the disputed buyout existed somewhere in September of 1988, in a form far more complete than anything Salpeter and Barkett's team could reconstruct more than a decade later, after records had been archived, discarded, or simply lost in the ordinary churn of a small business changing hands. By the time Salpeter and Barkett's team went looking for those same records more than a decade later, some of what might have existed in 1988 was simply gone. There is also the matter of tunnel vision, a term criminologists use to describe what happens when an investigator settles on a suspect early and then, consciously or not, interprets every subsequent piece of information through the lens of that early conclusion. Once McCready decided within hours that Marty was responsible, several decisions that followed appear in retrospect to have been shaped by that conclusion rather than by an open evaluation of the evidence. the decision not to pursue Steuermann's finances aggressively in the earliest, most useful window. The decision not to treat Steuermann's disappearance as urgent enough to warrant a wider search before the trail went cold. The decision to interpret Marty's numbness as guilt rather than as one of the most common responses to acute trauma documented in the psychological literature. None of these decisions, examined individually, necessarily proves bad faith. Together, they describe an investigation that closed its own aperture within a single day, and then spent the next 2 years building a case within those narrowed boundaries rather than outside them. If you've made it this far, you already know this channel is different. Subscribe to Dead Ends and stay with us for every case that was never truly closed. Because this case, unlike so many we cover on this channel, does not end with a name attached to the crime itself. No one has ever been convicted of killing Seymour and Arlene Tankleff. Jerry Steuermann was never charged with anything related to the murders, and he largely stepped out of public life in the years that followed, giving few interviews and offering no further explanation for the days he spent hiding under a different name. Joseph Creedon and Peter Kent were never charged with the killings themselves, despite Glenn Harris's sworn statement and the chaplain's corroborating testimony. The case remains, in the most literal sense, an open homicide investigation with a dismissed defendant, a business partner who disappeared and came back, and a confession that a unanimous appellate court eventually agreed was never actually a confession at all. It is worth pausing on how unusual that is, even within the world of wrongful convictions. Most exoneration cases eventually produce a second name, a real perpetrator, identified through DNA, through a later confession, through a cold case match. The Tankleff case never did, not in any way that satisfied a courtroom standard of proof. The people closest to the case have their own private convictions about what happened in that house on September 7, 1988, but none of those convictions have ever been tested at trial because no one besides Marty Tankleff has ever been formally tried for it at all. What happened to Marty Tankleff after his release is, by the standards of wrongful conviction cases in the United States, an unusually determined second act. He enrolled first in college and later in law school at Touro Law Center on Long Island, in the very state whose prosecutors had built a case against him on a fabricated claim, graduating in May of 2014. He did not pass the New York State Bar exam on his first attempt. He was admitted in April of 2017, nearly 3 years after graduating, a credential that requires a character and fitness review most people convicted of a violent felony would never clear. A review he cleared, on the strength of a record that by then no longer included a conviction at all. He has spent much of his career since advocating for other people convicted on the basis of false or coerced confessions, working with organizations focused on exoneration and criminal justice reform, and speaking publicly about the exact interrogation tactic that took 17 years of his life. Several states have since adopted rules requiring the mandatory recording of custodial interrogations, particularly involving minors, a reform that, had it existed in September of 1988, would have produced an actual recording of what McCready said to him in that room, instead of a single detective's handwritten summary that no one else was ever able to verify. New York's own rules on the subject have evolved unevenly since, and according to defense attorneys who track the issue, still leave gaps for exactly the kind of informal, unrecorded exchange that shaped this case. Tankleff pursued the civil side of his case separately from the criminal dismissal. In January of 2014, while still finishing law school, he was awarded $13.4 million in a settlement with New York State over his wrongful conviction. A second case, filed against Suffolk County and several of the individuals involved in his original arrest and prosecution, took longer to resolve. Represented in part by attorney Barry Scheck of the Innocence Project, Tankleff reached a further settlement with Suffolk County in April of 2018, this one for $10 million. No amount of money restores 17 years, and Marty has said as much publicly more than once. He has also said consistently in interviews given over the years since his release that he does not know with certainty who killed his parents, only that he knows with total certainty, built on nothing more complicated than his own memory of that night, that it was not him. He has since married and started a family of his own, a fact he has mentioned publicly in the context of what the 17 lost years actually cost him. Not simply time, but an entire alternate version of adulthood, the version where he might have married in his 20s, started a career in his 30s, built a life without a wrongful conviction as its foundational event. Instead, he built that life afterward, later than he should have had to, with a law degree earned partly as a form of personal reckoning, and partly, he has said, because he wanted to be able to help people going through some version of what he went through, from inside the system rather than shouting at it from outside. That choice, to spend a career inside the exact profession that failed him so completely, is, in its own understated way, one of the more remarkable details of this entire case, and one that receives far less attention than the 17 years themselves. There is a particular kind of injustice in this case that is worth sitting with, because it is not the injustice of a broken alibi, a mistaken eyewitness, or a piece of forensic evidence later proven flawed. It is the injustice of a lie constructed specifically to exploit the one thing a 17-year-old in the worst hours of his life had no way to verify for himself: what his own father, lying unconscious in a hospital bed 20 miles away, had or had not said. James McCready did not need physical evidence to build his case. He needed only a teenager's trust in the basic honesty of the adult questioning him, and a few hours of exhausted, grief-stricken uncertainty to work with. It worked exactly as intended. It worked well enough to convict a teenager of murdering both of his own parents, and it took 17 years, a retired detective working largely without pay, an attorney who never stopped filing, and the eventual, hard-won cooperation of a man named Glenn Harris for it to come undone. It is worth asking, plainly, how many cases like this one never get that second look? How many convictions built on similar tactics simply stand unexamined? Because no retired detective happens to work the case for free, no attorney happens to keep filing for 2 decades, and no witness ever decides, years later, to finally talk. Marty Tankleff's case did not resolve because the system caught its own mistake. It resolved because a small number of people outside the system refused to stop looking. Jerry Steuerman largely receded from public view after his interviews with investigators and reporters in the early 1990s, running his businesses on Long Island for years afterward without ever being formally tied in any courtroom to the murders that upended his former partner's family. He died years later of causes unrelated to the case, without ever having addressed in any sworn or public forum the specific question of why a man who says he had nothing to hide chose to shave his beard, adopt a false identity, and let word of his own death circulate through his community. To date, no criminal charge anywhere in the United States has ever formally connected Joseph Creedon or Peter Kent to the deaths of Seymour and Arlene Tankleff, despite Glenn Harris's sworn statement placing them at the scene. That distinction between what investigators came to believe happened and what a court of law has actually confirmed happened sits at the center of why this case remains genuinely unresolved, more than 17 years after the wrong man walked free, and more than 3 decades after 2 people were killed in their own bedroom. Andrew Cuomo's investigators, in that same June 2008 motion, had already declined to pursue a prosecution against Creedon, Kent, or anyone else connected to Harris's account, finding that the defense's own theory of the murders was not, in their judgment, supported by clear enough evidence to bring to trial. That finding drew criticism from people close to Marty's case, who pointed out that the same broader justice system that had once been willing to convict a teenager on a single unrecorded, unsigned, half-recanted statement was now unwilling to bring a case against three named men, Creedon, Kent, and Harris, supported by a sworn statement, a chaplain's corroborating testimony, and forensic evidence involving a bloodied sheet that had never been fully investigated in 1988. Whether that asymmetry reflects two genuinely different evidentiary standards, or simply how much easier it has always been for prosecutors to build a case around whoever is already in the interrogation room, is a question this channel cannot resolve any more definitively than the Special Prosecutor's Office did in 2008. What is certain is that the decision left the case exactly where it has sat since, closed for Marty Tankleff and open, in the most literal legal sense, for everyone else. Belterre is still a quiet village on the north shore of Long Island. The house on Seaside Drive has changed hands more than once since 1988, and the current residents, by most accounts, are aware of exactly what happened there. Somewhere in a Suffolk County Records office, an unsolved double homicide file still bears the names of Seymour and Arlene Tankleff, technically open, technically unsolved, still without a name attached to it that any court has ever confirmed through a conviction. Marty Tankleff did not get his childhood back. He did not get the years his parents should have spent watching him become an adult in freedom rather than in a cell built on their own deaths. What he eventually got was the truth catching up, slower than it should have been and never entirely complete, because several of the people who might have answered the remaining questions have since died, disappeared for good, or simply never been compelled to answer under oath. He confessed to nothing that any court, looking closely enough at the actual record, could honestly call a confession. He was innocent. It took the state of New York 17 years to agree. It took a lie, told in a police interrogation room to a 17-year-old who had just found his parents attacked, roughly 6 hours to work. There is a version of this story that ends more neatly, where the second man is named, tried, and sentenced, where the file in that Suffolk County Records office finally gets closed with a conviction attached to it, where the word unsolved no longer applies. That version of the story has not happened, and at this distance from the crime, with key witnesses dead and evidence long since degraded or lost, it may never happen. What remains instead is a narrower kind of resolution, a wrongful conviction identified, acknowledged, and reversed, a man given back his freedom if not his lost decades, and a case file that will likely sit for as long as anyone currently working in Suffolk County law enforcement is alive, exactly where it has sat since 2008, closed for the person wrongly convicted and open, unresolved, for everyone else who was ever a name on the list of people who might have done it. That is, in the end, the particular shape of this dead end. Not a mystery with no suspects, but a mystery with too many unresolved threads and not enough will this many decades later to pull on any of them again. Somewhere on Long Island, the people who were teenagers alongside Marty Tankleff in the fall of 1988 are now in their 50s, with children of their own, some of whom have never heard the name Belterre and would have no reason to. The tennis courts where he practiced that summer are, in all likelihood, still there, resurfaced probably more than once since 1988, used now by a generation of kids with no connection to any of this. That is what a dead end eventually becomes, given enough time. Not a wound the world keeps returning to, but a fact filed away, remembered clearly by a shrinking number of people directly touched by it, and by anyone willing to go back and look closely enough at what the record actually shows. Marty Tankleff still lives on Long Island, not far in the end from where all of this began. He still practices law. He still, by his own account, gets recognized occasionally by strangers who remember the case or who read one of the books written about it, and who ask him, sometimes gently and sometimes not, what actually happened that night. He tells them, consistently, the same thing he told a jury in 1990 that did not believe him, and the same thing an appellate court finally accepted 17 years later. That he does not know who killed his parents, only that it was not him, and that a detective's lie is the only reason anyone ever thought otherwise. It is, when you say it plainly, a simple sentence for something that took 17 years, a retired detective working for free, a defense attorney who never let the case drop, and a unanimous appellate court to finally establish as fact. This has been Dead Ends.